So welcome to our substantive discussion of jurisprudence this morning, and we are discussing legal realism. Legal realism. Let me share my screen with you. So we will try and understand generally legal realism. What is it? And then we look at the two schools of legal realism. That is the American school and then the Scandinavian school. So first of all, legal realism is the school of legal philosophy which emerged in the 20th century, mainly from the United States and Scandinavia. The US, we'll be talking about it. One particular judge, Oliver Wendell Holmes, who having served as a justice of the Supreme Court for many years, began to promote certain ideas of what law really is. We'll talk about that. But realism basically provides a challenge to the formalist approach to law. The formalist or legal formalism, as we hinted when we're discussing analytical, legal positivism, they take the view that the law is very logical, but legal realism challenges such a notion that is not legal decision can be derived from statutory or constitutional state. That is the formal is that, if you want to know the law, just look at the relevant legal materials, be it the constitution, be it the statutes, or even be it the case law, the jurisprudence. That, according to legal realists, is too simplistic. And there is something much more than that. So it's not really what formalists are thinking. It's not just a question of, for example, in Ghana, consulting Article 11 about the sources of law and say that all that you need to do is to find what the sources of law are and be able to work your way regarding what is going to be the outcome, what is going to be the situation in a particular set of facts. Legal realists say that that is really not the case. Rather, if you want to understand the actual workings of the law and how the law is going to play out in various set of fact patterns, various situations, we must rather look at the personal, social, and political factors of the judges, the personal background of the judges, social and political factors. And these are the matters which are the subcurrents, the operating at the subconscious level, if you like, of those who do adjudication. And those are the matters which actually impact on outcome of cases, as it were. So therefore, the legal realists reject any categorization of a legal concept which does not have basis in reality. They reject abstraction, or they reject metaphysics, as it were. They reject absolute values. For example, justice. What is justice? For them, if a concept cannot be reduced to empirical verification, that is practical, if you cannot relate to the the concept in a practical sense, then it's not worth considering when we are trying to understand the nature or the phenomenon of law. So therefore, realism is more concerned with the law as it is than the law, than what the law is in theory. So it's not so much about the theoretical aspect of the law, but the actual workings of the law. As some scholars will put it, like the law in action, the law as working rather than the theoretical understanding of the law. So it is preoccupation with the actual operation of the law in its social context. How does the law really work in the everyday happenings of society? So for realists, as I indicated, it's not so much about you worrying yourself that, oh, to know the law, let's try and find out the relevant legal rules, like the sources, the principles, the doctrines. No, that is not really the way to go. And for them, legal rules are often vague. Legal rules are often vague and they are abstract and they're even contestable, meaning that they don't have settled, core meaning, as it were. And they are amenable to, debate. So they should be interpreted. And because of this aspect of legal rules, according to legal realists, that they are not really having a settled meaning and they are contestable, they are necessarily subject to broad interpretation. And that is where the challenge comes. And that is where they think that it is wrong to be so fixated with what the former legal rules are. Just to look at the provisions of the relevant statutes, the constitution, or even like the decided cases, and I think that you have what the law is. That is too simplistic. Again, legal realists note that judicial precedence is not enough. You cannot just rely so much on judicial precedent, on the case law, because sometimes judges do not apply the rules or the principles mechanically, but they use their discretion in their judgments. That there's so much discretion which is at stake, and that is why for them, stare decisis or judicial precedent is not enough, or is not that which actually illuminates the path of the law or guides us. So as I indicated, we have two main schools of realism. We have American realism on one hand, we have Scandinavian realism on the other hand. And in the early 20th century, American realism emerged primarily to focus on the application of law and the role of judiciary in shaping legal outcomes. And the basic thesis posited or advanced by American realism is that law is not set of abstract rules, but it is influenced by social, political, economic factors, as we have indicated. So these are the matters which actually condition or shape law. So we have leading scholars, like Oliver Wendell Holmes Jr., Carl Llewellyn, Jerome Frank, among others, who all emphasize the unpredictability of judicial decisions. The fact that you cannot be very accurate in predicting judicial outcome. And for that matter, it is necessary to draw on empirical and sociological methods in legal studies, that we should also pay attention to sociology. We should pay attention to, on the ground, what is happening practically. Now, Scandinavian realism, on the other hand, at this stage, like, we are just trying to at the introductory stage to see what each of them look like before we take the individual proponents or the scholars within the various schools or traditions. Now, the American realism, the key features or the characteristics which we can observe: judicial pragmatism, the belief that judges often make decisions based on practical wisdom and experiences rather than solely on legal precedents or statutes. So it's not only statutes or precedents which actually guide judges, but also their practical wisdom, their lived experiences, as it were. And in fact, we will come across the famous statement by Oliver Wendell Holmes that the life of the law has not been what? Has not been logic. The life of the law is essentially experience. Another observable feature of American legal realism is empirical analysis. They advocate for the use of social science techniques to study law and legal institutions. So if you go to the social sciences, the sociology, social work, and so on, the various methodologies that they use, collecting data, studying, and in order to understand certain things happening, American realists would say that those social science techniques need to be drawn upon to study law and legal institutions. So, for example, if you want to understand a particular area of the law, they will say that it's important to also look at the practically on the ground what is happening. Even the judges will, for example, deal with certain cases. What type of society did they grow up in? And all those things would actually condition their appreciation of things. The third observable feature of American legal realism is that law is seen as a social tool, is viewed as an instrument for social change, that law can be used to bring about social change. And of course, that actually brings out the social impacts of law. On the other hand, we have Scandinavian realism. In the literature, some other scholars will also call it the Nordic legal realism. Because when we are talking about Scandinavian countries, these are like the Nordic countries. So the same thing. And it came slightly later after the American realism. And it's quite predominant in Sweden and Denmark. These are Scandinavian countries, or what we call the Nordic countries. So prominent scholars within that include Azel Haggerstrom, Alf Ross, the Lanstes, among others. And just like the Americans, they are also interested in trying to explain the law as it is. The law as it is. Not the law as in the statute books or the law as we like it, but the law as it is. Now, Scandinavian realism diverges from American realism in this particular way. They focus more on linguistic and philosophical aspects of law rather than the judiciary's role. American realism comes from the point of view of the role of judges, the role of the judiciary. in stating the law, in interpreting the law, and so on. But for Scandinavian realism, they try to look at the use of language in communicating a law and how that actually affect what the law really is. So the observable features of Scandinavian realism include the linguistic and philosophical approach. That is to say that Scandinavian realists, they stress the analysis of legal language and concepts. So for example, of course, we discussed Hofelden analysis of rights not too long ago. He's not a Scandinavian necessarily, but then that kind of exercise gives some credence to their thinking that language by its nature being open-textured, language being elastic, language producing shades of meaning and so on, certainly affects what the law is, as the case may be. So for Scandinavian realists, they argue that legal rules are statements about the behavior of legal officials and not objective truths. So let's get it. How do legal officials, those appointed or set up by the law, how do they actually behave with respect to their rules, instructions? Now, the statements about behavior of these legal officials, according to Scandinavian realists, is what the law really is, and not really about objective truths, as it were. Another feature of Scandinavian realism is that they see law or legal science as a moral science. In other words, it is a view of Scandinavian realists that legal science, law, is a branch of moral science concerned with the study of normative concepts. So for them, you cannot divulge, if you like, law from a moral science, as it were. And they also have skepticism, that is, they have doubts regarding metaphysical concepts. And don't forget that just like their American counterparts, that the American legal realism will tell us earlier on that any concept which cannot be reduced to empirical verification is not worth considering as far as legal philosophy is concerned. In a similar vein, the Scandinavian realists are also critical of metaphysical notions in law, like natural rights. If you remember last semester when we were talking about social contract theories, some will talk about natural rights and so on. And rather, they advocate for a more empirical and logical approach to legal analysis. So therefore, for us, American realists see law as a legal science that predicts how judges will decide cases. Scandinavian realists, on the other hand, they see law as empirical knowledge of social facts. Empirical knowledge of social facts, not so much about prediction of outcome of cases, as it were. And again, we will notice that American realists are more concerned with courts and the workings or the operations, of course, of courts. Whereas Scandinavian jurisprudence is concerned with the legal system as a whole. And that is another major thing. So American realism, because it's come from the point of view of the courts, you may hold the view that it does not have adequate explanatory power for the entirety of the legal system. Because after all, it's not everything which actually end up in courts, are still part of the law, the legal system. But the Scandinavian jurisprudence, as we will notice, is not so much about the court, but trying to look at the legal system as a whole. So maybe in terms of direct comparison, what is the focus of each of these two? American realism is more concerned with actual practices of law and judicial decision-making, while Scandinavian realism focuses on the linguistic and normative analysis of legal concepts. Linguistic, that is how language, how language is deployed, how language is mobilized to try and communicate certain legal ideas or legal concepts. And in terms of methodology, we also have some, is another parameter for comparison. You've seen American realists use empirical methods to analyze the law's impact on society, whereas Scandinavian realists employ philosophical and linguistic methods to understand legal language and its implication. So one is interested in understanding the use of language in crafting law and how that really impacts on what the law really is. Whereas another is interested in rather trying to use practical methods to understudy how judges, for example, will think about the law and how they use the law and how they apply the law. From the point of view of legal theory and practice, we also note that American realism seeks to reform legal practice. They seek to bring about reform in legal practice by acknowledging that external influences on judicial decisions, so we should look at how those influences, for example, could be curtailed or could be moderated so as not to really impact on judicial decisions. And those external factors, as it were, it's difficult to control them if we don't try to organize the law in such a way. Otherwise, that is actually what will be counting at the end of the day when judicial decisions are made. In contrast, Scandinavian realism aims to clarify legal reasoning and critique foundations of legal thought. For them, there should be a scientific and a rational approach to legal theory. So they're also thinking of like some kind of like a scientific methodology, as it were. Of course, both have been very influential and have left a lasting legacy, so to speak. So with respect to American legal realism, for example, there is another school of jurisprudence we call the critical legal studies, CLC, leveraged on by later schools like feminism, postmodernism, we will be discussing that later on. So all those relatively new, strands of jurisprudential thinking actually develop from American realism. So let's keep that in mind. Now, Scandinavian realism has also been influential in the sense that it also shaped how modern legal positivism and even modern legal philosophy in the whole of like the continental Europe actually developed in a way. So they've all been quite influential in one way or the other. Good. So now let's take American realism and discuss it fully, and then we will later take Scandinavian realism, having actually appreciated the unique characteristics of each of these major schools of realism. So to start with, but before that, maybe let me pause if there's if any question, or you can just put it down as we move along. Maybe as we get more information, you will be able to participate. So American realism. The American realists seek to put a more sociological account of law. And that is why we say that they look at the law in action and that they reject formalism. Formalism, those analytical positivists who held the view that law is more or less like a clue system. It's all just a question of looking at the logical connection and deduction of the rules as exists on the statute books or as exists in the constitution or the case law. They reject that kind of approach, the formalism approach of positivists. So formalism basically is a mode of reason which takes the view that legal reasoning can be likened to syllogistic reasoning, like how syllogism is done in logic. So in symbolic logic, syllogism, we just talk about, you have like your premises, and then certain conclusions are made. So for example, you say that you have a legal rule, apply it to the relevant facts, and then you get the judgment. So that is a very simplistic, logical appreciation as far as formalist approach to positivism is concerned. On the other hand, it is a view of American realists that this approach of just seeing law as just being a matter of having the relevant legal rule, applying it to the relevant facts, and you have a particular outcome of judgment, understates the power of judges to make law. If you look at it that way, it becomes too simple. Then you ask yourself, do judges actually make law? Do judges actually make law? Then you say no. But for them, that is exactly what they do. So the realists are preoccupied with empirical questions. They try to identify the sociological and psychological factors which inform judicial decision making. What school did the judge attend? What were some of the ideas which were actually invoked in that school? So all those are some of the things which emphasize, which operates on the mind of the judge as far as the American legal realists are concerned. So they reject the notion that judges are strictly constrained by legal rules. That is to say that they don't think that it is correct to say that when judges are seized with cases, they have no room to do what they think best, and that they are just hemmed in by the rules. American realists, they disagree. They say that that is really not the case. And they would rather want to attach greater significance to the moral and political intuition about the facts of the case. There are various contributors to American realism, as we have noted in the very beginning, but we can distill certain common points running through them. One, the conception of law in flux, that is, of moving law and of judicial creation of law. That is to say that law is not static. Law is evolving, and it's evolving because the judges are actually creating law, as it were. And you have come across judicial activism before. Then the conception of law as a means to social ends, not as an end in itself. The law is not an end in itself. Law is a means to social end. Conception of society in flux, that the view that society is not static. Society is also evolving very fast and even faster than the law. Fourth, the temporary divorce of is and ought for purpose of study. So for them, the is ought question is very important. Then they also have a distrust of traditional legal rules and concepts as descriptive of what the course of people actually do. They don't think that if you look at the traditional legal rules and concepts, they provide a good account or a good description or a good narrative of what really goes on in the courts or what people do in the legal system, as it were. And they also have a distrust of the theory that traditional prescriptive rule formulations are the main factor in producing court decision. That is to say that they don't think that, for example, in Ghana, you have Article 11, which are the sources of law in Ghana. And then you'll be told that if you have to deal with anything concerning the legal position, you should be able to locate that particular rule or that legal principle within what is considered the formal sources of law, let's say under Article 11. And that if you cannot do that, then that cannot have the badge or the label of legality. Now, American legal realists would actually disagree, and they would say that there's something much more than that. So they also, they believe in grouping cases and legal institutions in narrow categories, that we can group cases and then institutions into certain compartmentalization based upon certain realities which are observed empirically. Of course, they also manifest an insistence on evaluating law in terms of its effects. The law should be evaluated not on its own terms, that is according to the rules themselves, internal coherence. That is really not important. What is important is that what effects, what consequences is the law producing? The consequences or the effects are what should be looked at in trying to evaluate, in trying to find out whether the law is worthwhile, whether the law is adequate or not. And of course, they also manifest an insistence on sustained and programmatic attack on problems of law. So let's look at some of the proponents or the scholars. Oliver Wendell Holmes Jr. Is said to be the father of American legal realism, and he was Supreme Court justice, for many years. And he basically founded and inspired what we call American Realism. According to Holmes, examination of facts must be the basis of jurisprudence. Let me take water. Must be the basis of jurisprudence, because for him, jurisprudential concepts by themselves are not capable of verification. And if they are not capable of verification, he recommends that they should be rejected. So it is only those concepts which can be verified when we employ practical information, facts on the ground. Those concepts which can be verified, those are the concepts which are worth keeping as part of within the jurisprudential province, as it were. So Oliver Wendell Holmes made the argument that the life of the law is essentially experience. It's essentially experience. And this is how he put it. Let me just quote from. So the life of the law is essentially experience. The pragmatic and empirical aspects of law are all important. Indeed, although the language of judicial decisions is largely the language of logic, behind the logical form may often be detected an inarticulate and unconscious judgment, the very root and nerve of the whole proceedings. Hence, the apparent certainty of the law is mere illusion. Repose is not the destiny of man. So simply, Oliver Wendell Holmes is saying that, yes, we may think that when the courts work, when judges work, is that they are just applying the law using principles of logic, apply the law to certain facts. And that is really how it is. And for that matter, we can have a certainty of the law. Oliver Wendell Holmes is saying that that apparent or that supposed certainty of the law, because we are thinking that judges just apply their mind with respect to the logic of the principles of the law in relation to facts to have an outcome. That is too simplistic, and that is really not true. That is really not the case. For him, political and moral theories, which the judges subscribe to, or which were part of the training of the judges in their schools, their various encounters, intuitions of public policy, how judges view public policy, and certain prejudices or predilections which judges share with their fellow men are far more important than syllogism, far more important than the logical application of the rules in determining the rules by which men are governed. So the background of the judge, the worldview of the judge, the type of society, the ideological exposure, all those things, according to Oliver Holmes, are important in influencing how the judge will understand and apply the law to a particular situation. And for that matter, if you ignore those things and you are just looking at the rules and trying to find out from maybe deductive reasoning or inductive reasoning, using like the logical reasoning to apply the law to a situation, you may get it wrong because there are certain inarticulate inarticulate, that is unexpressed and unconscious judgment going on in the mind of the judge, as it were. Now, Oliver Wendell Holmes was a very firm believer in the distinction between law and morality. In the study of law, in his view, there should be deliberate exclusion of every word of moral significance, as they have little consequence in any analysis of operational matters. That you don't have to confuse the two. So to Oliver Wendell Holmes, the law is actually what the court say it is. The law is what the court say it is. It is a set of consequences emerging from the practices of the court. It is not a system of reason or an amalgam of deductions from ethical principles, no. If you want to know what the law is according to Oliver Holmes, look at what the courts are doing, and then that will give you a sense. So in his famous work, he wrote a work in 1897, and that work was titled The Path of the Law, The Path of the Law. And in the Path of the Law, he talks about what we call like the prediction theory. And what did he say? He said that the prophecies of what the court will do, in fact, and nothing more pretentious, are what I mean by the law. The prophecies of what the court will do, in fact, and nothing more pretentious, are what I mean by the law. I mean, just before I continue, I have a class I teach a civil procedure students in the law school. I was with them yesterday, and they said that their criminal procedure lecturer invited them to follow her to the court because there's a certain at the prosecution which is going on at the murder case or something like that, and they were telling me that what they saw in the court is different from what they are actually studying in the books or in the classroom, because they've seen like the law really in action. Of course, that is not like a best analogy, but just also reinforcing what Oliver Wendell Holmes is telling us, that when you talk about the law, it is actually what the court say it is. So for him to know what the law is, one must look at the bad man. The bad man does not care about the niceties of the legal language. He doesn't care about the section, the subsections, the sub-rules, the orders. The bad man doesn't care about that. He cares about only the material consequences. If I breach the law, if I violate the law, what will be my desert? What will be the consequences for me? So the bad man is interested in the material consequences of the law, and not the logical presentation or whatever. No, they are not interested. So we can recap his contribution to American legal realism. Oliver Wendell Holmes advanced, just like the general tenor of American legal realism, that there's a practical approach to law. And his emphasis on pragmatism was evident in his assertion that law should be understood and evaluated based on its practical effects rather than its abstract principles. And that is why he made the point, quote, "The life of the law has not been logic, it has been what? Experience." So it is the lived experience of people in relation to the law, the real world outcomes of the law, which is important. Then he also talked about the bad man theory, as we have just explained. His famous work, The Path of the Law, introduced like the idea of the bad man theory, which basically posits or postulates that law is best understood from the perspective of a person who is only interested in the material consequences of legal decisions rather than moral or ethical consideration. So he said that, yes, if you want to have a predictive view, be able to tell what the outcome or what the legal position is going to be, you must not focus on just the legal rules, but focus on how the legal rules are applied in practice and how they guide behavior. And don't just look at their moral or intrinsic values. The moral or the intrinsic values of the law mean nothing. What really matters is how they are applied by officials or by judges, as it were. Of course, we also talk about the fact that he had the skepticism towards a legal formalism, and he said that it is wrong for anybody to think that legal decisions will be deduced logically from established principles or precedents without regard to social conditions or consequences. And Oliver Wendell Holmes argued that judges make law and that their decisions are influenced by a variety of factors, including their own experiences and societal values. And to him, these are the subjective elements in judicial decision-making. And these subjective elements in judicial decision-making actually make it difficult or complicated for anybody to be certain about the law. And that is why it takes a view that we have indeterminacy of the law. The law is not certain in the sense that those who are going to tell us what the law is, they are influenced by so many subjective factors, as it were. Yeah, so basically, those are the things we should remember about Oliver Wendell Holmes. But as we have noted from last semester, that no philosophy, for that matter, no legal philosophy or school of jurisprudence is immune from criticism or from some defects or deficiencies. And certainly, Oliver Wendell Holmes is not an exception. So therefore, some have put up the argument that the pragmatic approach of Oliver Wendell Holmes to law, and particularly his emphasis on judicial discretion, could undermine the predictability and the stability of the legal system. After all, what is law supposed to do? If you talk about rule of law, right? If you talk about rule of law, one of the virtues of rule of law is that we are supposed to have some element of stability, some element of predictability, because the legal rules are there and they are transparent, they are known to everyone. So therefore, why can't we rely on the legal rules as publicly known by everyone for us to be able to foretell what situational outcomes will be. We must rather have to wait and worry ourselves about subjective factors, which are going to work on the minds of the judges that will have to tell us what the law is before we know what the true legal position is. So critics says that Oliver Wendell Holmes' view of emphasizing the pragmatic approach to law, and particularly how he discusses the judicial discretion, really has the tendency, and a very serious one, to undermine the predictability and stability dimension of the legal system. Of course, that notwithstanding, we cannot dispute the fact that Oliver Wendell Holmes has influenced the American legal realism, even if people still disagree with his claims. Another proponent or contributor to American legal realism is Carl Lewin. You've come across Carl Lewin already when we started Jurisprudence, the introductory part, especially when we read in the chapter 1 and 2 of Lloyd's Jurisprudence, M.D. Freeman Lloyd's Jurisprudence. Carl Lewin, he was an accomplished poet, pugilist, and a linguist, someone interested in the use of language, as it were. And he did a number of write-up, including the common law tradition, and then the realistic jurisprudence, the next step, and so on. Now, as far as Carl Lewin was concerned, legal rules are not as important as some legal theorists claim they are. It is how a rule works that determines its significance. And they are not to be thought of solely in terms of verbal formula. Because for him, rules are what they do. Rules are what they do, not just how they appear or how they are intended to be, but they are what they actually do in fact. And that is why he cautioned that how rules are communicated through the text of the law are not important as what they actually do on the ground. So for him, if you are to do a study of rules and you seek to omit ideology, you seek to omit people's ideals, as it were, you ignore the realities of the law. So it is the operational significance of rules of law, which in Carl Lewin's view should be considered or should be studied. So his contribution was founded on the concept of functionalism. So for Carl Lewin, law was always a means to social end. Law is not an end in itself. So the law was an engine which had to be examined in terms of purpose and effect. An engine which has to be examined in terms of purpose and effect. Law has a certain purpose or purposes. Of course, if you look at his work, you talk about the law jobs, okay? If you look at his work. So law has certain purposes and not a value in itself. So in order for society to survive, certain basic needs must be satisfied. And this engenders conflicts, which must be resolved. So it takes a view that, yes, if society is to be worthwhile, society is to flourish so that human beings can live meaningfully in it. There are certain things which should take place. And those things or those basic needs which should take place are such that the pursuit of them will naturally bring about conflicts. And because the pursuit of those things will bring about conflicts, it becomes necessary for law to come in to manage the conflict. So law, in Carl Llewellyn's scheme of interpretation, constituted an institution organized around the performance of necessary social tasks. An institution, such as law, in using Carl Llewellyn's language, is made up of techniques, precepts, rules, and ideology. So therefore, law serves certain fundamental functions. What Carl Llewellyn called those fundamental functions, he called them the law jobs, okay? Law jobs. And I remember when we were reading M.D. Freeman's law jurisprudence, in the very beginning, we came across this concept of law jobs. So if society were to function, certain law jobs should be performed. So what are these law jobs? Llewellyn identified, let's say, 5 law jobs. 1, the disposition, that is adjustment of trouble cases. Perhaps the most important of the law jobs. So Llewellyn said that it is the work of a basic nature which must be done properly in a sufficiently large number of cases if society is to remain a coherent unit. So work of this type, that is the resolution of disputes, the settling of grievances, act as a test to decide which legal rules prevail in the real world. Mind you, he has already reminded us that certain basic need should be made possible in a society. However, the pursuit of those basic needs by people in society will necessarily engender or create conflicts. And if we need to manage the conflicts, then law has a function to perform. That is disposition or the adjustment or the management of those troubled cases, mediation of those troubled cases. So adjudication becomes important for us to know who is entitled or who is not entitled, as it were. And that is why he said that if societies be a coherent unit, there's a need for this law job, that the disposition of troubled cases. So the courts or mechanism for resolution of disputes are a very important part of what law is supposed to do in society, because whether you like it or not, we are bound to have differences. We are bound to have disagreements. And where we have differences, disagreements, or tensions, those tensions need to be mediated. They need to be resolved. And that is resolved through adjudication or some other recognized means of a settlement of disputes. And 2, the other law job is the preventive channeling of conduct and expectations in areas of actual or potential conflict. And this is intended to head off collisions and consequent disputes. So that is another law job. Law is supposed to manage people's expectations, especially in those areas where you are likely to get actual conflict, or there's that potential of a conflict. Now, if law is able to manage expectations, you avoid unnecessary, if you like, clashes or collisions and eventual disputes. The other law job is the allocation and exercise of authority or jurisdiction within society, which Llewellyn refers to as arranging the say and its saying. Arranging the say and its saying. In other words, we are talking about legitimacy of settlement of dispute and subsequent procedures. There should be a proper system of judicial decision. Who has the power to make certain determinations or pronouncements? And how are they carried out? All this should happen within a certain scheme. And that brings about legitimacy and is important. Then fourth, the provision of directive and incentive through the organization of society as a whole, which involves the total effect of the three previously listed law jobs. So we should put in place arrangements, incentive or motivations, which will enable the law job we talked about initially, the settlement of disputes or troubled cases, managing expectations, that's the preventative channel of conduct and expectations, so as to avoid conflict, actually or potentially in the first place. And also allocation and exercise of authority or jurisdiction, proper giving of jurisdiction. You must have an arrangement. So, for example, how like the court structure, the Courts Act, the Constitution, which actually set up like the court system, which gives that jurisdiction. Whatever level of court can do, cannot do, what powers, and so on. So that when, for example, an order is made, because it's coming from a recognized source of authority, it's giving that legitimacy, and then it can have effect in terms of implementation or execution. So all those things should be organized properly. Then five, the provision of an appropriate juristic method, which involves law as a technology and embraces the maintenance and improvement of law structures and the traditions and skills of the official craftsmen of the law. So as we are putting together institutions to deliver on this law job, it is also important to think about the techniques of working of the judges, so as to bring about efficiency, as it were. And later on, you notice that some scholars have actually, especially after the Second World War, have built upon some of the ideas of Carl Llewellyn, and have introduced what we call the jurimetrics, which seeks to cover application of communication theory and the use of mathematical logic in law in relation to jurisprudential inquiry. So, for example, now that we even have like an AI, artificial intelligence, it can, for example, load judgments of the courts into a scheme and then try to find out certain patterns and certain factors which might have probably explained certain outcomes. Then they are grouped in those orders as it were. But as I said, it all has to do is a further refinement of the fifth law job that there should be appropriate heuristic method, that is, which involve law as a technology, which ensures that those who apply the law, that is the official craftsmen of the law, the judges, the courts, and so on, they are able to sharpen their tools and are able to efficiently do their work, as it were. So to Carl Llewellyn, the most important job of the law is the disposition of trouble cases. And this is to be done by officials of the law. And what these officials say about law in the disposition of disputes is what the law is. So that is the basic argument that is leading us with. We also have Jeremy Frank, another contributor of American realism. And Frank also served as a judge of the Second Circuit of the US legal system. And he made a distinction between rule skeptics and fact skeptics, as it were. Rule skeptics and then fact skeptics. Now, the rule skeptics are concerned with the appellate courts, and they omit the unpredictability in the judicial process. So they are concerned about how appellate courts, that is the case which have been decided already by the trial courts, they go on the appeal and how things turn out. Those are the concern of the rule skeptics, as it were. Now, the fact skeptics, on the other hand, are concerned to uncover the unconscious forces that affect discovery and interpretation of the facts of a case. So, as you will notice, we have trial courts and we have the appellate courts. The trial courts are the courts of first instance, like when cases occur, where they go to first, and then the court will have to take evidence and make determination as to whether certain things happen or did not happen. We do fact findings and so on, as guided by the law of evidence. So those things happen in the trial court. Now there, the fact skeptics, according to Jeremy Frank's version of American legal realism, the fact skeptics are holding the view that when you go to the trial court, especially where findings of fact are made, the judges there are not just using the law of evidence and then just the evidence before them, but there are certain unconscious forces, certain silent forces operating on their mind, which affect the discovery and interpretation of the facts of a case. So basically, that's the point that the fact skeptics actually seek to make. So therefore, if, for example, somebody has been a victim of maybe somebody's relative has been a victim of armed robbery, okay, and then cases of that, for example, come before that person as the trial court, as it were, in trying to make the fact findings as whether certain things happen or did not happen. And the fact skeptics will say that that experience of that person's relative and so on, which is part of the unconscious forces operating on the mind of the judge, is going to influence how the person actually decide whether certain things happened in the, for that matter, robbery or did not happen. On the same vein, if someone has been a victim of rape or sexual harassment and so on, and matters, for example, of that come, those that person's own view about things will definitely cloud or influence how he interprets the particular fact. So to Jeremy Frank, certainty of law cannot be achieved through legal rules. You cannot just look at the legal rules and think that, oh, you know certainly what the law is. No. So he identified himself with the facts skeptics and believed that various prejudices of jurors and judges crucially affect the outcome of a case. And mind you, in America, jury trial is quite common in a lot of cases. And this happens at the trial court. So the jurors, their background, a jury who, for example, has had certain experiences before, the way that you interpret certain things are different, and so on. And for him, according to Jeremy Frank, if we are talking about the law, we should be interested in the fact skeptics, those unconscious factors which actually influence the minds of those who are making fact findings at the trial level. So Jeremy Frank put up the argument that law cannot be separated from the decisions of the courts. You cannot separate law from the decisions of the courts. So it is necessary to understand the basis of judicial decisions. And this, in his view, required an investigation of a variety of factors, such as emotions and hunches, and so on. So the law is in relation to set of facts, a decision of the court relating to those facts. So that is the law. The law is not just on its own, but how they are applied to facts. And how they apply to facts is the court making that decision. And until the court has given its decision, no law concerning those specific facts is in existence. So, as far as those specific facts are concerned, we don't know the law yet until the courts have spoken, until the courts are giving their decision regarding it. So, the law, in his view, is also essentially uncertain. Now, Jeremy Frank argues that rules are mere words. In any event, the court will indicate what rules mean, whether contained within the statute or implied in the opinion of some other court. And rules are not to be found on the basis of a judge's decision, no. Those decisions may be arrived at before he finds a reason for them. So the judges will arrive at the decision, and having arrived at the decision, try to find a reason for them. In other words, it's reminding us that what the courts decide is not just the rules which arrive at that decision. Some other factors will let the courts reach a decision. And then, having reached the decision, they will just try and look at the available rules and pick rules which sort of justify the decision. But it's not the rules themselves which resulted in that decision. Some other factors, some other background or unconscious factors. But then you must justify the decision by the available rules. And for that matter, since knowledge of the rules alone is of limited value in predicting the outcome of a trial, it is necessary to turn for guidance to a study of other matters. The other matters which actually lead the court or the judge to arrive at the decision is what should be studied rather than just the rules, because the rules are not the one which actually decide. The rules are just secondary. The judge will arrive at the decision and try to look at which of the rules should I pick as the basis of my decision. Just some kind of an ex post facto rationalization. You try to pick the rules which are, for example, allowing the decision, but it's not the rule which really led you to arrive at that decision. Some other things made you arrive at that decision. So the prejudice of a jury may be of a disproportionate significance in outcome of legal proceedings as it is well. Yes, American realism is very interesting, but as we have indicated, no legal theory or school of jurisprudence is immune from criticism, and they be criticized for being too simplistic, oversimplification of what things are. For example, to read law of moral terms is to take from it all significance. Can you read law of all moral consideration? Certainly not. And again, if we are talking about pragmatism and empiricism, in the final analysis, they are abnegations of the search for truth. Is pragmatism and empiricism a sure guide to the truth? Not all the time. And again, to regard law as what the courts will do in fact is oversimplification, which disregards the phenomenon of error and appellate review. So if law is what the courts will do in fact, why do you have appeal? Why do you have reviews? Why do you have judicial review and so on? So the fact that we have those things means that we have some other standards for appellate review. Again, that judges may have common standards. And it is also said that they may be aware of secret or private norms, which they consciously attempt to disregard. And that there are many areas within the systems of law in which discretion may not be exercised, and in which statute and precedent may exclude creative lawmaking by judges. And this is a legitimate criticism. There are so many areas in the law where there's no room for discretion. In other words, the court cannot do any other thing than doing what the law says it should be done. When, for example, it comes to, you've all done the law of succession, okay? When it comes to wills, for example, when it comes to wills, the law said that, for example, if you're talking about statutory will, the will should be in writing. It should be signed by the executor, witnessed by at least 2 witnesses. Can a court say that if a will is in writing, signed by the executor, but there's no attesting witness, can the court give effect to it as still a valid statutory will? Certainly not. So there's no discretion in that matter, as it were. Again, Jeremy Frank's general concept of law as lacking certainty is difficult to reconcile with, for example, the existence and workings of a vast world of commerce. If you take the world of commerce, if you take commercial law, contract, and so on, if you look at the cases in the contract and commercial law, one of the policy rationale emphasized is the need for certainty and predictability in the world of commerce. When it comes to commercial engagement, people should be certain that the rules of engagement are going to remain as they are without any radical changes here and there. Yeah, so we will actually draw the curtain down here, and our next class we continue with the Scandinavian realism. So unless there's any question, otherwise I'll be drawing the curtain down here. And then we are not doing the company law today. As I said, we do it the time that I send to you tomorrow evening. If you have any question, I'll take it before I end the class. Okay, so I'm not seeing any hand. So we shall meet later on tomorrow. Have a good day.